The credit repair industry is a beautiful industry. The credit repair industry is predicated upon hope. We transform lives and help others to live their dreams after they sometimes mess up. We are a second chance industry. What we do is very precious, but what we do is very fulfilling. However, there are certain things that we must understand when we're a part of this industry. In this video, I'm going to discuss how to make sure that you are compliant. How to make sure that you are compliant. Because the credit repair industry is one that is not that difficult and challenging to get in. In most cases, some states have different restrictions and different aspects of the credit repair industry. Some states require you to be bonded, and the bond has different price range. What I want to discuss is for you to set up yourself to make sure that you are compliant and you don't find yourself violating the law. So as a credit repair business owner, there are certain fundamental things that you must have in place in your business in order to be compliant, where you cannot be sued by your customers or be fined or even sued by the FTC or the CFPB. FTC. There are several paperwork that you need to have that a lot of times credit repair owners are not aware of. So I'm just going to give you a few things that you need to have in place to make sure that you are compliant and make sure that you are not vulnerable to the things that are going on. Let me deal with the first one. The first one is in your marketing. I see a lot of violations taking place in the marketing and credit repair, that most credit repair owners, because they are not familiar with the laws that govern credit repair, they violate these principles and find themselves in problems, but because no one has ever fined them or come in and basically causing harm, they don't know. In your marketing that you do, whether it be on social media, whether it be orally, whether it be you're putting up signs in your jurisdictions that you live, you cannot make any guarantees in your marketing. So for example, I would see ads where people are telling possible potential clients that we clean all negative things off your credit guarantee. You can't do that. That's a violation of CROA, the Credit Repair Organization Act. That's a violation there. And it's also a violation of Section 5 of the FTC Act. Because if you put that out there and tell your client that there's a guaranteed removal, especially if you give a time frame, I see in the video I'll give a time frame, and you don't fulfill what you promised within that time frame, then you have violated the law and you can be fined. And if your clients know, they can sue you. So that's one. Make sure you don't make any guarantees. Advertise your stuff in such a way where you're not making any guarantees or outright promises that are materially provable that you can be fined for. That's the first thing. Number two, if you get a client through the Telemarketing Act, which have a specific section for credit repair companies, for example, if you get a client through cold calling, right, or through certain mediums, you cannot charge them until after 6 months, until the service is actually done and completed. So once you get them through telemarketing medium, and there is a list of telemarketing medium, you just need to look on that section. Lexington law was just found by the FTC last year. A devastating amount of money. You can look it up and you will see, and it's because they get their client through telemarketing mediums and they charge them before the service or whatsoever they promised to do was completed, and they fine them for it. It's a if my memory serves me right, I think it's about 1.2 billion or several $100 million. I think Lexington Law, which is the biggest credit repair player in the industry, I think they have to file bankruptcy for a few of their subsidiaries, because Lexington Law doesn't just operate one company, they have a few under their belt. It's because they violated the Telemarketing Act. So make sure you understand that. That governs you. Number 3, you cannot charge your client before the service is provided. So there are some games that are presented where I hear individuals online and other mediums speaking, and what they are saying, they don't know that if they do that and make that argument, they will go down with the fines. You cannot charge any upfront fees before you provide the service. So what we have a lot of times is a standard processing fee and also a monthly fee. And individuals sometimes charge that fee on the very first day that they meet the client or they onboard the client. You can't do that. You cannot do that. If you do that, it's a violation of the Credit Repair Organization Act, and it's also a violation of other acts. You cannot charge the client before you have completed the service. You got to do what you promised to do, and then you charge them. So you gotta put together your dispute, you gotta send out your dispute, and then you can charge the client, because what you promised to do is done. And make sure in your contract you state that that's the kind of service that you will provide. If you don't state that in your contract that you are giving to the client, and then you actually do that, then you will come up as a violator. You can't say that you provide consultation and credit repair is free and you're charging for the consultation. No. If you're doing consultation where you're not doing the actual work, the dispute, then that's different. That is different. But once you are gonna do the work, you cannot use that argument. The courts have seen that argument, and you're not gonna get anywhere with it. You cannot tell them that you don't provide credit repair, it's free, and you just charge for whatever reason you want to make up a retainer's fee. Can't do that. The courts have seen that argument. You will go down. You just need to comply with the law. Whatever you say you're gonna do, just do it. Make sure it's spelled out in the contract. Make sure it's spelled out in the contract. You cannot. That's number 3. After you do your contract and it's spelled out what your duties and the service that you're providing will be, then you gotta give them under the Credit Organization Act, you gotta give them several disclosures. You gotta give them a customer bill of right that states that the client is able to do all that you are doing themselves under federal and state laws. And there's a list of things. There's specific things that got to be in this disclosure. Specific things, so you can't just make up one. There's specific things, and if you don't give this, you can be fined. You got to give them a cancellation notice disclosure telling them that prior to midnight of the 3rd day after the contract is signed, they can cancel the service without any penalty or anything, any loss of money or anything like that. You got to give that before you can charge them. You cannot charge them before the 3-day period. You can take their credit card information, and after you do the service, I don't, especially new clients that I have no formal relationship with, I don't charge them prior to that 3-day period, because if they want to cancel, then I don't have to do any refund or any chargeback. And you know how it is with the credit repair and your merchant account. So I don't charge my client before the 3-day period of the contract being signed. I am not in any rush to take your money because I don't want after that then you say, oh, I want to cancel, and then I have to refund you and then have a chargeback. So the best thing to do is don't charge them until after that 3 days. Take your time, put together your disputes, and then after midnight the third day, once you send out your dispute and you have proof, then you are able to charge them, and you gotta give them that disclosure. As a credit, then that's number 4. Number 5, that's number 5, I think. Number 6, as a credit repair organization, you are under the Graham-Leach-Bailey Act because you are doing financial activities, which means you need to give them their privacy disclosure. You don't have to give all the disclosures that are required under the Graham-Leach because you're not sharing their information with unaffiliated third party. If you are doing that, then you gotta, if you are affiliated with others and you are sharing their information with them, you gotta disclose that to your customers. You got to tell them that, because you will be under Graham-Leach violation if the government comes in and press you. You gotta retain the records of your client for 2 years after you have done service with them. That is a cruel requirement. You gotta retain the records of your credit repair clients for 2 years. You got to. So all of these things you got to do to be compliant. Now, if you are not doing third party sharing of their information, you just need to give them a privacy disclosure. Tell them how you deal with their non-public personal information, because as a credit repair company, we deal with the most sensitive information and clients. So you tell them in your disclosure, your privacy disclosure, that you don't share their information with any third party. And that's it. Once you do that, then you don't have to give all of the other requirements under the Graham-Leach-Bailey Act that is required for financial entities, because you're not doing sharing. You just need to tell them that you don't share their information with anybody. So you have those. Then you have the contract that you must issue. So you have, let me run that back by you, all of what you need to have. You need to have the cancellation notice disclosure. You need to have your privacy disclosure. You need to have your contract. You need to have the customer bill of rights. And then you need to, what I do, I have my contract, the standard contract that has certain language in it. And then I have another document relating to the contract that is a bit more specific on exactly what I do. Avoid any guarantee language in your contract. Avoid it. Avoid it. I know that it is tempting to tell your clients, oh, I am going to do this to let them be happy. Explain to your client how the process works, that you are dealing with third parties, and from your past experience, you know that certain things can be done. But you cannot guarantee on the basis of that past experience that this is what will be done. To protect yourself, once you do all of these things, you will be okay. These are the things that you need to be compliant. Do not make any upfront guarantee in your marketing or even when you're speaking to your client. Do not do it. If you do it and you don't deliver, you can be out. Your clients can come after you. The FTC can come after you. Please don't do it. Those are the basic things that you need to make sure that you're compliant. And all of these disclosures that you have, some of them need specific language. The law tells you the language that must be in the disclosure. So if you're running a credit repair company, you need to know these things, and you need to set up your things properly. You need to retain for 2 years the record of your clients from the date of that contract. So make sure that you understand that, and you're properly storing and documenting your clients' information and the contracts that they basically have. Every contract that you have, save a copy of it. Save a copy of the contract and the basic information that you have on your clients. Once you're doing this, you will be compliant. Alright, I will finish here. There is more that could be said. And remember, if you get your client through telemarketing, it's a whole different ball game with the telemarketing act. Whole different ball game. You can't charge them until after 6 months. So if you do not get any client and cold call unless you prepare to do that, unless you prepare after you finish the service completely, then you actually can charge them. I don't want myself to be in that. No business can be run that way. Credit repair companies have a black eye in the industry, and the black eye is there because of a few bad actors, and there's active, there was and there still is active agents that are on the loose to black the eye of credit repair companies. So make sure that you stay on the good side and you're doing things the right way. I hope this is helpful. Peace.